Stephen Antle is a dispute strategist. He's a senior partner at Borden, Ladner, Gervais in Vancouver and a chartered arbitrator. He's an expert in preventing and managing all kinds of commercial disputes and, if necessary, resolving them through ADR, administrative proceedings, or litigation. He has a broad range of experience. Oh, there's a microphone for me too. Yeah. Sorry, no one told me. But I won't start again. Sure, I'm happy. Are you? Are you happy? Stephen has a broad range of experience emphasizing strategic corporate guidance advice, including shareholder disputes, domestic and international commercial arbitration, contract troubleshooting, and international dispute resolution issues. He advises and represents corporations and individuals involved in a wide variety of business and has appeared in as counsel before mediators, domestic and international arbitration tribunals, administrative tribunals, all levels of court in British Columbia, and the Supreme Court of Canada. Having sat on an arbitration panel with Stephen, I can tell you he's an excellent dispute strategist and has a great analytical mind. Stephen? Thanks, Jim. I'm now going to introduce the panel, which I'm going to do very quickly. We have a very experienced panel of in-house counsel here, and I don't want to waste time introducing them. I want to get right to the meat of what they have to say, because quite frankly, I'm keen to find out what it is. On my right is Sven Deimann. He is the head of legal codes and standards for Bombardier's transportation business unit. Sven was first called to the bar of Berlin in November 2002, joined the Barreau de Quebec in 2009 as conseiller juridique étranger d'entreprise. He joined Bombardier Transportation's German operations in June 2002 and has been in a variety of in-house counsel positions, supporting diverse business divisions and governance units of Bombardier Transportation since January 2003. On his right is Barry Fisher, a commercial arbitrator and ADRIC's brand new pro bono general counsel. Barry recently retired as Vice President, General Counsel, and Corporate Secretary of SAP Canada. He began his career practicing corporate securities and international law in a large firm in the U.S. Midwest, returned to Canada, practiced Canadian law with major law firms, and as a foreign legal consultant opened the Toronto office of his, I guess, former U.S. law firm. Barry has served as an arbitrator for the AAA on several international commercial arbitrations. And on Barry's right is Doug McLean, Associate General Counsel and Director, Litigation, Arbitration, and ADR of TransCanada Pipelines. And in that role, Doug deals with litigation, dispute resolution, and insolvency matters in Canada and the U.S. And in that capacity has appeared before a variety of courts and tribunals. He was admitted to the Law Society of Alberta way back in 1977. One caveat before we get going here, I expect you are going to hear some distinctive individual views from these panelists, and we want to emphasize that these are their views and not necessarily those of their current or former employers. So with that, we're going to dive right in. We have a number of topics to cover. In each case, one of the panelists, or in one case myself, will take the lead and talk for a few minutes about that topic, and then we're just going to throw it wide open to the rest of the panel and to all of you. And we do encourage you to ask questions, make comments, get into arguments. We do draw the line at fistfights. But we hope to stir some debate here. And the first topic we're going to talk about is what I'm expecting that most of us in the room are arbitrators and arbitration counsel, and we have been known to go on at length about the potential benefits of commercial arbitration compared to litigation. What these folks are going to talk to us about is what are the benefits of commercial arbitration that are important to in-house counsel, and Doug is going to take the lead on this one.
In terms of benefits seen by in-house counsel, I think one of the first ones that comes to mind often, particularly around budget time, is arbitration should be a faster, less expensive means of resolving disputes. Faster and cheaper, however, is certainly not guaranteed by the fact that I will try. Faster and cheaper dispute resolution, however, is not guaranteed just because you put an arbitration clause in an agreement. or because the parties have selected it. I think achieving faster and cheaper dispute resolution is something that the parties need to work at. Initially, when dispute resolution clauses are worked out, and throughout the process once arbitration is triggered. And I think some of the comments and the discussion that will follow with this panel will give you some ideas of what sort of work needs to be done by the parties to get there. Confidentiality, privacy of the process, and the result is another thing which is near and dear to the hearts of in-house counsel. The ability to resolve disputes outside of the public eye is often an important factor in the parties selecting arbitration for a variety of reasons, including protecting disclosure of sensitive or proprietary information, privacy of proceedings, which allow decisions and resolutions from necessarily setting precedents for other potentially similar disputes that a business may have. This can be of significant importance to businesses which have dealings with many customers, clients, or end users. Privacy of proceedings can also foster much more conciliatory approach by parties, which may allow for resolution and allow parties to continue to work together in long-term contracts. The ability to select decision makers is often given as a reason. I'm sure that further on in this we're going to have some dispute or debate about how that gets achieved. But the idea of having disputes resolved by decision makers who are knowledgeable about the business issues involved in the disputes, or knowledgeable about technical issues that may arise in the course of the arbitration are important to the business clients. Certain qualifications relating to types of disputes that might arise, for example, real estate, accounting, oil and gas, can be specified as requirements for selection of an arbitrator. Arbitrators with a familiarity with certain types of cases may also be looked for when selecting an arbitrator. Unlike cases in courts where generally you're going to get the judge that's assigned to you, you may have a commercial court which provides some types of panels with a little bit more experience, but with arbitrators you at least have the idea notionally of getting people who will understand your dispute. I think of prime importance is the ability to shape the process. This is something that arbitration has that you can't really do in litigation. The ability really to tailor the nature of the arbitration process to the nature and magnitude of the dispute. Issues like discovery, motion practice, experts, production of documentation, scheduling can all be dealt with by the parties in crafting their clauses and crafting their agreements once an arbitration is triggered. The finality of the decisions is something that can be provided for specifically in the agreements. And that also is a specific thing that is of particular importance to businesses. To get a final result within a period of time, limiting appeals certainly has the potential to shorten the process. So, those are my general comments.
Sven, do you have anything to add to that?
Well, I'd like to focus on a couple of points that Doug's mentioned. He started out with the faster, cheaper. And on that point, maybe conjuring up a bit of controversy here, I would think my experience would be that's a bit of a relative point. Yes, of course, you can have arbitration rules and forum which are cheaper than state court and litigation in state courts. However, what you need to know is, of course, with arbitration, with the forum, and with whatever you want to invest, you also have the quality that you get in return. So yes, you can go opt for a forum which is cheaper, but you must bear in mind it could have an impact on the quality of the service you get in terms of the administrative services, support work for the panel. So that's one point. For us, as a result, I think the more salient feature is the second point about confidentiality of arbitration. It's non-public nature. You'd appreciate our business involves dealings with transit agencies, authorities, or rail operators, all very much in the public limelight. And so if we have disputes with them, we typically have a preference that this would not be done actually in public. Conversely, we sometimes have clients, especially those owned by the state, who will tell us we're never going to sign an arbitration clause because we are owned by the state and we need to openly show our confidence in the state court system. Notably a big operator in Germany who keeps coming back with that and prevents us from signing arbitral clauses there. Towards partners, when you're delivering a huge infrastructure project as a total transit system, typically you team up with civil works, civil engineering companies. The situation is somewhat different. Here, the benefit of arbitration I really do see in terms of it could lead to faster ongoing rolling dispute resolution as opposed to a big wash-up, one-time big litigation in state courts.
Barry, your thoughts?
Just two quick observations. One is that the interest of in-house counsel is often, and I emphasize the word often because it's not always, and we'll get to more of this later, the inexpensive and rapid resolution of disputes, and recognize that this is often also not a core competence of ours. But the fundamental benefit for me, and the most important is, and not mentioned yet, is winning an enforceable award. That's in our interest. And I pose the scenario in which any of us come back to our board and our CEO, and we describe all of the beauty of an arbitration hearing in which the arbitrator conducted himself wonderfully and the counsel were intelligent and the process was fine. Everybody's happy. There's just one problem. We lost. And I can tell you, any CEO I've ever worked for, that full stop immediately. And they'll turn to you and say, okay, well, what do we have to do to appeal? I'm sorry, we used an arbitral process that has no appeal mechanism. And just hope at that point you didn't choose the wrong subject matter and bet the crown jewels in an arbitration process.
Okay, anyone else have any thoughts? Anything from the audience? All right, then we've got lots to cover, so we'll keep going through it. The second topic we want to deal with is if those are the benefits of commercial arbitration that are important to in-house counsel, how do we actually realize those benefits? I think we all know that it's not as simple as slapping some arbitration provision in your contract, but how do you make these potential benefits real? Doug?
Yeah, I think Barry's comment provides a useful segue there too. I think drafting of arbitration agreements or drafting of the agreements which will govern the process of the arbitration are fairly critical and require both thoughtful negotiation and preparation. When you're drafting the actual agreement, the clause that will trigger the arbitration, I think the things that are important to recognize is that there's no easy button for creating an arbitration clause. I think the discussions that we've had on the panel are fairly consistent that quite often if you're the person who has the experience in arbitration, at the last minute somebody phones you up when they've negotiated some major agreement and wants to know what should we put in for the arbitration agreement? What clause should we have in there? And the answer obviously is going to have to depend on what's the nature of the agreement. What are you trying to cover? Is this a relatively straightforward agreement? Is this some massive agreement that will have a 10 or 15 year term? Is this an agreement which will take you from the development stage through to the construction of some major project? pretty obviously, if you put in a clause that says every dispute or any dispute that arises under the arrangement will give rise to arbitration, you're going to create a recipe for just a terrible mess. You need really to be able to look at this, recognize that one size does not fit all when it comes to arbitration. You basically need to end up with a process to resolve your disputes that's appropriate for the problem that's created. And it gives rise often to multi-tiered dispute resolution processes and agreements, or sometimes just to very simple clauses which will indicate that disputes are subject to arbitration, reference to some set of rules that will provide a process, and allow the counsel to get involved, or the parties, once the dispute arises, to tailor the process to the problem that they have on the table. Selection of arbitration counsel is obviously a key to achieving the results that you want. If you've got a bet the farm or bet the company piece of arbitration, you're going to probably want to take exactly the same kind of steps, use the same amount of detail as you might if you're going to litigate the issue. This is a pretty common experience in the U.S. where arbitration, commercial arbitration, has basically just supplanted much of the civil litigation, largely because it allows parties to avoid juries. It puts them in a forum where proceedings are private or fairly confidential, and allows them to govern the process. They often use the same rules as they would in litigation. That's not necessarily a bad thing, depending on the nature of the dispute. But if you have a much simpler, much more straightforward type of a dispute, that's not the kind of process you want. In a case where really achieving a relatively streamlined process is involved, I think there you want not necessarily your typical trial counsel for civil litigation or commercial litigation. You probably want a fairly specialized counsel who deals a great deal with arbitration matters and is skilled in working with the level of detail that's necessary, particularly in the production of documents and discovery, which generally leads to the significant expense to get the results you want. Selection of appropriate arbitrators, this is something we touched on. A single arbitrator obviously is more likely to be able to hold an arbitration and ultimately render a result in a much speedier manner than if you're trying to schedule 3 arbitrators' time along with the counsel involved. The nature of the dispute is such that you need very specific expertise and knowledge, then that's something that you need to look into the background of the arbitrators. This is very inexact science from my perspective. You need to look at the CVs of the arbitrators, use the organizations that often are behind the selection processes, who will give you a range of candidates. They can provide people with particular expertise. You look to your counsel, who may have familiarity with the arbitrators whose names get put forward, or who have colleagues that will. A caveat that you need to keep in mind when you're looking for expertise in arbitrators is you don't necessarily want someone to come to the table to decide your issue who already has his mind made up about certain types of things. And that's a particular potential problem. You don't want predetermined ideas.
Barry, do you have any thoughts on this subject?
Just Just one, that I think we need to recognize that benefit for one party is not necessarily a benefit for another. That is, the party who's looking for a rapid and inexpensive resolution to a dispute may have an adverse interest to the person who would recognize that that is not in their interest necessarily to have that happen. And therefore, you have to anticipate the kinds of disputes that are likely to arise and then draft accordingly to try and control the process.
Sven?
I would concur with that, that obviously the level of detail you can see in arbitral clause should ideally always be a reflection of the particular situation in which you find yourself in. If you're dealing with a huge contract for a huge infrastructure project to be delivered over X number of years, where okay, with your civil works partners, you're going to work on this for 4 or 5 years. Typically, I think you might be more in a situation where you would want to consider a clause going a bit in the way of continuous rolling over adjudication as opposed to a one litigation, a one dispute, big panel to deal with everything. I'd like to come back to the issue of the selection of arbitrators. This potentially, of course, is the one feature of arbitration which can be its biggest advantage, because indeed it does allow you to shape the process, to select people in line with what your interests potentially can be in arbitration proceedings. At the same time, our experience has been it's also the biggest challenge, because if you really want to make it a success, if you really want to reap the full benefit of this possibility that arbitration holds out for you, you need absolutely good fundamental advice from people who are in the know, who can direct you to arbitrators well suited for your particular case. So that's always a bit the two sides of the coin that come into the play here.
Okay, unless we have any other comments from the panel or questions. Oh, we have a question. Yes, ma'am. Depends how loud you can talk.
I don't even know if this is on. So going back to selection of arbitrator and expertise, I'm just wondering if your panel can comment further on that. The way I see it as an arbitrator is that you don't want the arbitrator to come with the decision already made, so I've heard that. However, when we're looking for expertise, so let's just take as an example construction issues, I think it's important from what I've seen that the arbitrator know and understand the context. What is a change order? What is a CCDC? All those kinds of things. But can you comment further relative to the importance of having that structural engineering qualification versus just simply being able to be open to hearing the evidence from your expert witnesses on structural engineering issues from the architects, as an example?
Any of you have any thoughts on that?
Just a quick thought. It depends whether the dispute is highly technical in nature. The more technical the dispute, the more I would be inclined to have an arbitrator who has a very technical background. Other than that, I think you need somebody who has a general understanding and isn't gone so far with that expertise as to, as Doug points out, prejudge the issue or think they're smarter than the presenters in front of them and therefore is persuadable.
Do you notice that when you choose technical expertise, as an example, and again, an architectural issue, do you give up some of the expertise on process that, for instance, a lawyer can provide to the process?
I don't think necessarily. If you're selecting an arbitrator because they have some kind of technical expertise, you're perhaps trying to simplify the job the counsel has in explaining the technical issues to the panel. It's not necessarily going to be a replacement for having an expert witness who may have to speak to the issues, but it potentially puts someone on the panel who's in a better position to receive some of that information.
I think Doug also raises a relevant point that to the degree to which this becomes highly technical, that may move you away from a sole arbitrator to a panel in which you have two people with that background, and then you have someone with a procedural understanding who acts as the neutral.
There's a division here between the role of the arbitrator and the role of an expert witness. And what I often like to approach this, the way I often like to approach this issue is to look for an arbitrator who is first and foremost an experienced arbitrator, but who in their practice, whether as arbitrator or as counsel, has experience in whatever field it is, construction. And then when you get to the really technical stuff, you do that through the expert witnesses. But you do want to have an arbitrator who, they may not be an engineer, but they've done a bunch of construction litigation. That's kind of the compromise that I come up with sometimes. Okay.
Thank you.
Okay, we're going to move into our next topic, which, sorry, go ahead, please. Sorry, can you use the mic? Just.
I think the problem with the arbitrator was too technical, or very technical. It would be in competition with the experts. And I have seen that in the panel, so that the problem is if it's too technical, he would like to have his own version of the solution, instead of the solution of the proof, which is made in front of him.
I think something.
I think that's the problem I was alluding to. And it's a difficult balance to try and make. And ultimately, you're never going to have enough information to make the perfect decision. Additionally, you've got the other party involved, and if you have a panel of three, whoever you put on the panel, they have put someone on with their own thinking involved in that process, and then you'll have a chairman of the panel as well. So, I mean, it's a highly inexact science, and you can do the best you can, and that's about it.
Okay, let's move on to our next topic, and this is Sven's topic, and he nicely segued into it before we got sidetracked with those questions. The third topic is, we've talked about the benefits and how they're important and how they're realized, but everybody in this room knows of an arbitration horror show where those benefits were not realized, where they went 9 times to the Court of Appeal and everything became public and the dispute took longer and cost more to resolve than if it had just been done as a standard lawsuit in the Superior Court. So the question for Sven is, why does that happen?
Okay. Thank you. Well, I think one of the fundamental causes, in my experience, that we frequently see is, of course, that there are issues with the arbitral clause. That can be frequently the root cause for any arbitration that ultimately goes ski-whiff. I've heard arbitral clauses being referred to as the champagne clause, because by the time you get down to writing the arbitral clause, everything else has been agreed, so parties may no longer have the necessary concentration of mind to draft something carefully, which makes sure that afterwards, if it comes to arbitration, we don't see the horror shows. And one of the causes that you can sometimes, or that I've seen, is the arbitral clause simply says parties agree to refer all disputes to arbitration in accordance with the rules of, and so on and so forth. And then it makes no provision for how the arbitrators in a three-person panel are to be selected, or if it does say that each party gets to appoint one arbitrator, it doesn't say how the chairman is to be selected. And then you can end up with the chairman of a panel being selected for the parties by the respective forum or institution. And of course, what you need to see is, as we said earlier, selection of the staff, the personnel to decide your dispute. It's potentially one of the biggest benefits of arbitration. So if you forego that because of a not carefully drafted arbitral clause and you allow a forum to select the chairman for you, I think you can already have the ingredients for an arbitration process that will take very much longer, because you may end up with a chairman who may not be very familiar with the type of disputes, who may have other interests, who is chosen essentially not by you or the other party together, but by the forum. Another point, but this is maybe an issue of perception. Earlier during the introduction, you heard that my background is one in continental Europe. And we, of course, very much focus on arbitration with the perspective that, okay, you have more informal rules in terms of gathering evidence, presenting evidence. And whenever you come to Europe or to a European lawyer with a suggestion, well, but even in arbitration, we would like to have discovery, you can sometimes hear people howling. Discovery is not something that typically we like, and I think it is fair to say, from what I've heard, it is can also be one of the root causes for an arbitral process to go completely ski with, because the parties fail to agree on what is reasonable discovery, and then engage in an orgy of discovery requests back and forth that can last several months before you close the discovery proceedings. So here, of course, my experience, the appropriate middle ground would be, at the very least, if you're going into international arbitration, to agree on the IBA rules or comparable rules in national forum. Another point, and here maybe we'll have some discussion, because I'm not sure whether everybody would share that view, is in my experience, I've frequently been told by counsel, by external counsel, well, next week the panel has convened a meeting, a hearing, a first hearing to decide on the terms of reference for this arbitration. This is a technicality. We propose we attend this, and the panel also wants to have it maybe not as a physical hearing, but only as a phone conference. So don't worry about it. We're going to take care of it, and afterwards we're going to present you the results. And I have always disagreed with that approach. I take hearings and discussions on terms of reference extremely seriously, because that ultimately is the document that you will need to live with. And in particular, if you're in a situation where you know, okay, this arbitration is important, it's a one-time resolution of a significant dispute, it's absolutely crucial that you are involved as in-house counsel. You can actually infuse it with what you believe is in your interest. Let's remember that one of the big advantages also of arbitration is it potentially is a lot more flexible in terms of what process you have than state court litigation. So for me, it is absolutely crucial to be involved in the terms of reference, to be able to shape it in accordance with what I believe are the interests of my corporation when it has to go to arbitration. To give you an example, I've been in national domestic arbitration in Germany, where ultimately there was a discussion during the terms of reference hearings as to the level of formality with which you could challenge evidence, documentary evidence, to be presented in the proceedings. And we insisted on a possibility to challenge documents submitted as copies, where we believed we had reason to challenge the authenticity of the document. Ultimately, that arbitration was settled on that very specific procedural issue, because the other side submitted a document which we believed had been tampered with and was not complete. And we challenged it on that basis, and the arbitral panel, in the end, drew a negative inference in our favor.
Okay, just keep things moving along. Barry, do you have any thoughts on this topic?
A lot, but I'll try to keep them brief.
Okay, well, try and save a minute for Doug.
Okay. I see three main culprits in why disaster stories happen. The first are the parties themselves. And here it's particularly because they may have different interests in the outcome of what the arbitration is. Secondly, there may be an inequality of their positions or the budgets that they have associated with this. Thirdly, might be a lack of experience with the process itself. There may be an unwillingness or inability to actually control counsel, and there may be an unwillingness to cooperate in fencing in the parameters of the arbitration itself, so the parties can be to blame. The second major cause for disasters is the arbitrator, him or herself. And here, that person may not be qualified for the particular dispute at issue. They may have one or more what I call negative qualities as an arbitrator that I'll talk a bit about when we get to the selection of arbitrators. That person may be overscheduled, unprepared, disorganized, reactive, timid, or slow, all of which are formulas for disaster. May permit excessive document disclosure when the particular issue doesn't make it necessary, and may fail, on the other hand, to narrow the issues, evidence and argument, and give excessive concern for due process. Not to leave us out, or anybody who isn't touched by this so far, the lawyers are the third major culprits. Firstly, in-house counsel may not focus or control the process or their counsel, and in fact may see it as their mandate to complicate the process. And secondly and lastly, outside counsel may see it as their mandate to leave no stone unturned, which can lead to some particular difficulties in an arbitral process.
Just to add to those, I think the discovery issue is a key one. Discovery needs to be proportionate to the issues that are involved. And that's something that particularly the counsel involved and the arbitrator involved need to keep in mind and need to keep a focus on. The due process issue often seems to arise and gives rise typically to much more discovery than is really necessary. One of the ways that parties can control some of the discovery is by providing that the documents to be produced are the ones that the parties themselves are going to rely on, and then have some limited right for one party to request documents from the other party. That then the arbitrator is going to have a look at whether the request is overly broad or not. But the proportionality of discovery to the issues is absolutely key to controlling the cost, the length of time, because that's where a huge amount of time is spent. The other issues, and I agree with Barry, having the right parties involved is key to it. When you're drafting the arbitration clause, when the requests come for what do we put in for the arbitration or dispute resolution process, typically you're being asked that by the business lawyer in-house who's supporting the business development group who's put forward this project. Those aren't the people who are ultimately going to be involved from the business when this contract goes into place. The people who are going to be involved when you're actually building a project or you're involved in a joint venture with somebody are a wholly different group of people within your business. And in-house counsel needs to go and talk to them about, okay, well, what kind of disputes do you anticipate are going to arise in the course of this contract? And talk to them, and you will probably get a completely different perspective than you will from the business development group, who gets a bonus when this deal is done and they go away. The other thing is in-house counsel really needs to be invested in the process. And there are two ways that may happen. I mean, number one, in-house counsel may themselves be conducting the arbitration as counsel, or they may be working with outside counsel. If they're working with outside counsel, my suggestion is you get the business people whose problem this is involved in the selection of counsel so they're comfortable with counsel, and you have one or two of those business people involved in the process at all time, because it's their dispute, and ultimately it's their dispute you're trying to resolve, and they need to keep their thumb on the process. And they also will want to keep in mind that there are more ways to skin a cat than one. And the arbitration process may be one thing, and it can be going along on one track. They can still be working on a settlement track as well. But if they know what's going on, they've got a much better idea of how to get this dispute resolved. And it's their issue, their risk, and their money that's involved.
Okay, I just want to make a brief comment going back to what Barry has said about parties, and then I'll let Barry actually speak about a few examples of disastrous arbitration. Let's not forget arbitration, ideally, of course, and if the arbitral clause is well drafted, is final and binding. Now, if you have a process, the outcome of which is final and binding, and in the process, one of the parties realizes that it is very, very likely that it will lose this process, then of course you have a very, very strong incentive for that party to make sure the process does not run its normal course and until and is somehow being interrupted, stopped, or otherwise disposed of. So recourse to what one might call, I'm not sure whether that term has some coinage over here, but in Europe it's increasingly being talked about, recourse to guerrilla tactics in arbitration making repeated, recurrent demands for document production, submission extensions, challenges to the arbitrators and absence of bias, can of course be strongly enhanced if you have a situation where one of the parties believes it's likely it can only lose the arbitration and it knows the outcome is final and binding. Then you have a strong incentive to make it derail. I once had a German colleague, a comment is to be taken with a bit of salt, but who told me outright and very bluntly, if you have an arbitration file that you know you're in the process of losing, the only way to mitigate the risk for the company is you must make derail the arbitration.
Two quick examples of things when I was thinking about this that I wouldn't have anticipated originally as disasters, and they both come from south of the border. And one was a context in which a university engaged a set of architects who themselves then obtained design professionals below them. And on the other side had their construction manager and mechanical, they subcontracted then to mechanical contractors. Of course, a dispute arose. The mechanical contractor down here initiated an arbitration, had clause up and across to the university, and so all 5 parties got involved because there were indemnification provisions within. The process went on for a long period of time, millions of dollars awarded. The day that the arbitration award came out, the subcontractor over here initiated legal proceedings against the other subcontractor and won. Was able to pursue the remedies even though they'd all been, the res judicata argument didn't apply on a simple proposition that there was no privity of an arbitration clause between the 2 subcontractors, even though because of the indemnification clauses, they had been dragged into the same arbitration. So they ended up relitigating on a losing perspective the very issue that they'd been forced to pay under the indemnification clauses. So be wary of that. Second is a funny little case in which an arbitration clause provided that the parties be independent. The arbitration rules in application then, in this case the AAA rules, required that they be impartial and independent, as is typical in these kinds of clauses. And so but relying on their agreement, the parties proposed arbitrators that were, quote, partial to them, were advocates in some form. The AAA disqualified those arbitrators. It went on. There was an award, challenged the award, and it was vacated at trial. It was unvacated on appeal, and in the state Supreme Court was revacated. The process took 9 years, and they ended up back with nothing, again, on a simple proposition. So you can see where simple drafting issues can end up with disastrous results.
Okay, we're gonna move on. I'm gonna take you very quickly through something that's been alluded to a couple of times now, which is what are the key considerations in drafting arbitration agreements? So you've heard what can happen if you don't do it right. We don't have time here. We could take all day to discuss how to do it right, but what I'm going to take you very quickly through is what boxes you have to check. So the first thing is, are there going to be any preconditions to the right to arbitrate? And this is where we get into a pet peeve of mine, which is tiered dispute resolution provisions. And again, we don't have time this morning, so I'm going to restrain myself, and all I'm going to say about tiered dispute resolution provisions is if there is really a good business reason to use them, draft them really, really, really carefully with objective escalation criteria. And we'll leave it at that for now. The next thing that you have to deal with, and deal with very carefully, is the scope of disputes to be arbitrated. Because we're not in court here, there's no inherent jurisdiction. The arbitrator can't just deal with anything one party chooses to put in front of him. He can only deal with what the parties have agreed to put in front of him. And one of the few bases for not internationally enforcing an arbitral award is that it deals with something that the parties didn't agree to arbitrate. So you've got to have the scope. It's got to be very carefully defined. You should think about number of arbitrators. There's all kinds of considerations. We've touched on some of them in the questions from the, I assume, the construction lawyer. About expertise, there's all kinds of considerations, pro and con, in favor of one arbitrator or a panel of 3. You've just got to think about, as Doug said, what kinds of disputes are going to come up in this case, and therefore, how many arbitrators do I need? You may not have to spell this out in your agreement. You may be able to deal with whatever rules you're going to adopt, which we're going to come to in a second, probably has a default. You may just want to go with that default, but you need to think about it. You don't go with the default without thinking. Point that Barry just touched on, do we want to, and was touched on earlier, do we want to require our arbitrators to have any particular qualifications? My bias, frankly, is to have somebody who's an experienced arbitrator, and I don't really care a lot beyond that. In my view, the arbitrator is essentially performing the same function as a judge. At the end of the day, in his award, he is going to tell my client what their legal rights and obligations are, and I want somebody who is experienced in doing that. Whether they happen to be a registered engineer or a biochemist, I'm not as interested in that. I would probably want to deal with that aspect of the case through experts. But primarily, I want someone who is good at finding facts and applying the law to facts and determining legal rights and obligations, because that is fundamentally what an arbitrator does. Procedural rules. Doug talked about the importance of being able to shape the process. This is where you do it, in choosing rules and in choosing how to modify those rules. So, you know, starting from the litigation perspective, where there's one track and we all know what it is, we all know the road we have to go down if we're litigating, you can think at each step along that road, do we want to do it that way here in this arbitration? Do we need pleadings? I've done arbitrations with no pleadings. There was one issue, everybody knew what it was. Are we going to have, we talked about documents, are we going to have any disclosure of documents? Are we going to disclose reliance documents? Are we going to have the ability to compel disclosure of other documents? Are we going to have something broader than that? What are we going to do about documents? Are there going to be examinations for discovery? Generally, the default is no, something that litigation counsel can have a hard time getting their minds around. In fact, they're going to have to go into this hearing with no discovery. Scary, scary. Procedural timeframes. How fast are we going to do this? How fast can we do this? How fast can all of us do this? The in-house counsel, the business people, the external counsel, and the arbitrators. How available are they willing to make themselves to get this done? How is evidence going to be prevented? Another scary subject for litigators. Most arbitrations I've been involved in had essentially no examinations in chief. The evidence in chief goes in writing. Preparing that written document, therefore, becomes a crucial part of the arbitration, just totally foreign to the litigation mindset. And you just put the witness up there and say, great, cross-examine him, go to it, which raises interesting issues for preparing your witness, raises interesting issues when you're cross-examining that witness cold, with no lead-in, no direct examination. First thing the arbitrator hears out of this witness's mouth is a response to a question in cross-examination. Very different dynamic. Are we going to have a time frame for the award? I actually have an arbitration agreement on my desk in Vancouver that says the arbitrator will deliver his award within 45 days of commencement of the arbitration. Every time I get depressed, I read that clause and I laugh. The first thing I told my client about that was, this is never going to happen. You will never get anyone who you would want to decide this dispute to agree to this. So just forget about it. We're looking at 6 to 8 months minimum. Rights to seek judicial intervention, rights to appeal, all these things are issues to be dealt with in the context of shaping the process through the choice and possible modification of the procedural rules. What else do you have to consider in your arbitration agreement? Are we going to be administered or ad hoc? Are we going to get somebody to administer this? ADRIC, of course, the ICC, the LCIA, the AAA, back home where I come from, the BC-ICAC. What bang do we get for our buck? These people are going to charge us a fee. Some of the international organizations are going to charge us considerable fees. What do we get for that? Is it worth it? Do we need to do it? Why don't we just do it ad hoc? Then our arbitration is going to be administered by our arbitrator's legal secretary. Hopefully he won't charge her out at $1,000 an hour for doing that work. Got to think about all that. How are our rules going to work if we're going ad hoc? Some rules say if you want to use these rules, you must have your arbitration administered by this institution. Others don't say that. There are the UNCITRAL rules, which are specifically designed for ad hoc arbitrations. So figure all that. Confidentiality. Your rules will say something about confidentiality. It's obviously a key consideration according to our panel here. Is what your rules say about confidentiality enough? Do you need to say more in your arbitration agreement? You've got to think about that. the seat of arbitration, in my view, a crucial consideration which almost no one understands. The seat of the arbitration is not here, this room in Montreal, where we are seated doing the arbitration hearing. That is not the seat of the arbitration. The seat of the arbitration is a legal concept. It is where the arbitration notionally, legally takes place. It's crucial for two reasons. The law of the seat is the law that governs your arbitration, whether you agree on that or not.
And the award.
Yes, and the award that flows from the arbitration. And if you do have to go to court for all of the interesting reasons that have been discussed or some other reason, if you do have to go to court during your arbitration, you have to go to the courts of the seat, right? And you've got to think about, among other interesting questions, are you able to appear, you as counsel, able to appear in the courts of the seat, or are you going to need local counsel to appear for you? For example, if you are doing an arbitration in California, you probably are not able to appear in the California courts if it's necessary for the arbitration to go there to sort out one of these issues. You're going to have local California counsel do that for you. All things to think about when you're drafting. That's really about all I'm going to take you through. We've got a couple of minutes before we need to move on, so I'll open it up to the panel. Doug, do you have anything on that?
I think in terms of the tiered concept, it very much depends on the nature of the agreement that you're dealing with and the types of transactions that will come out of it. I think it's quite possible to put in some summary procedures to deal with particular issues, accounting issues, billing, invoices, review of joint venture costs, things like that, in construction contracts, processes to deal with requests for change orders, things like that. Things that can be dealt with in a relatively summary manner while the business continues to run. The typical tiered process of having senior business executive deal with things, I haven't found to be very successful. Others may have, but I tend to agree that you don't want a very complicated process, but you do need some procedures to deal with small issues that arise along the way, and you don't want to involve a very cumbersome arbitration process that may be suitable for issues of hundreds of millions of dollars or billions of dollars in a project when you're just dealing with a few thousand or a few $100,000 or a couple $1 million. So,
Barry?
To those of you that are litigators in the room, the way in which I would advise that you will maximize your billings on any file is to have three things. One, an ambiguous arbitration clause. Two, stubborn clients. And three, a weak decision maker. Combine those three things.
and add discovery to that.
Yeah, when it's unnecessary. Just to deal briefly with waterfall clauses, just to be clear, I mean, it's fairly common for people to put in that the parties will negotiate in good faith. Don't put any time frame on it, and then suddenly someone says, well, you're not negotiating in good faith. Yes, I am. No, you're not. Who's going to determine that? Well, we'll go to an arbitrator. Sorry, the arbitrator is only qualified once we have failed. So you're in the court. So just be cautious about things like that. Clauses that impose impossible qualifications. I mean, I've seen clauses that actually name an arbitrator. 22 years later, that person is maybe no longer with us, and then that arbitration clause fails. Jurisdiction clauses should be exclusive. Don't put a clause in that says the parties may, because the parties may not. And therefore you want something compulsory, put the word shall in. As to if you want to preclude appeals, and of course some jurisdictions and rules permit on issues of law, but they also permit an opt-out. So be conscious of the rules of the jurisdiction in which you are operating and contract out if that makes sense. Things like interests and costs, the award of punitive damages, these are all things that are in arbitrator discretion. If you don't want it to happen, there's a way you have at the early part of the process to control what an arbitrator can and cannot do, because that you could end up with a small award and this huge punitive damage award that you hadn't anticipated because you didn't draft properly at the outset. That's enough for now.
Sven, anything about arbitration clauses?
Maybe just two short comments. One, going back to qualifications. I think here what you need to remember is the more qualifications you put in, the more difficult you make it if you need arbitration to actually constitute the arbitral panel. So there's a bit of a weighing exercise to be done. On the one hand, it's of course beneficial. There's something pushing in favor of it because you want to make sure that whoever sits on the panel is halfway familiar with the type of contract that you're dealing with. On the other hand, the more qualifications you put in, the more difficult in the concrete circumstances it can become to actually constitute the panel. And by experience, even relatively minor qualifications, such as something you typically see more often in international commercial arbitration or international investment protection arbitration, such as nationality qualifications, can definitely have an impact on the length of time the parties need to constitute a full panel. The second point is about the discretion that you were talking about. You're absolutely right. Again, I think it harks back a bit to the point about the terms of reference and terms of reference hearings being very, very important for in-house counsel to be present, to have a handle on it, because that's where you determine those types of issues. And one of the issues that you need to address in any type of arbitral context when you actually come to constituting a tribunal is how much discretion you really want to vest into a panel. And again, it's a balancing exercise because on the one hand, I think you want a panel to have discretion because otherwise it makes no sense to put good decision makers into that place. On the other hand, you want to guard yourself against unwelcome surprises, so you want to fetter that discretion to some extent.
Okay, we're in the home stretch here. Next topic is what factors are important in the choice of a commercial arbitrator? Barry.
I could take you well beyond the home stretch on this very topic. I would like to suggest to you that the choice of the arbitrator is the most important decision that you will engage in the process. And you know, we see in various components when we have jury selection, all the background checks that are done. When I began practicing in the U.S., it was as a corporate and securities lawyer, but it was a big firm. In the first 6 months of our engagement, they rotated us through the litigation department, and one of the things that I observed, as soon as a judge was assigned to a particular matter, what we went out and we read everything there was that judge had ever written, because you could, and that included decisions, speeches, everything. You wanted to know as much about that. And I translate that into, in the days of Google and the information that is available about arbitrators out there. You can get redacted versions of awards that they have made. You can interview people who have appeared before them to get a sense of. So you can help to define what the qualities are of the person that you are going to engage. For purposes of this discussion, however, I want to point out what I call some qualities to avoid in looking at an arbitrator. And there's been a little bit of reference. The first is what I call the superego, someone who is an expert in the area, and I think we heard some discussion already that sometimes if the person thinks he or she knows more about an issue than anybody else in the room, they're not going to be persuadable, and they've already made up their minds before you begin. The second is a super lawyer, someone at the top of his or her game who will take over the process because he or she believes they have better advocacy skills than anybody else in the room, and so they will take charge of the process and be cautious of them. Third is a super adjudicator, someone who will simply overtake the process from the parties and not allow them to make their cases as fully as they may otherwise. Third is what I call a super savior, and that is someone who looks for issues of justice and truth and wants to change the world through, you're looking for a simple commercial resolution to a dispute. And the last is what I call a limperist, and that is someone who doesn't have control, is inexperienced, underoccupied, and just can't keep control of the process. So the kinds of things, though, I think that we, as retainers of you who are arbitrators, the qualities that we're looking for include familiarity with the law. and the arbitration rules that apply. Experience in the relevant industry so that they can appreciate the commercial significance of what they're hearing. Have legal or other views that are expressed through the publication of awards to get a sense of their experience. Language can be an important part of dealing with someone who is dealing in a second or third language, because sometimes the key issue in a case can deal with a nuance that isn't picked up if the language is not your first one. Experience with both the issues at hand and with the counsel at hand helps. And suitability, and that is certain qualities, listening skills, patience, fairness, competence, decisiveness, procedural competence, and sound judgment. But in sum, in an ideal world, the perfect arbitrator is one with a maximum predisposition to toward your case, but with a minimum appearance of bias. In the real world, however, recognizing that we're not likely, and none of you would ever confess to being such a person, those that are the most sought after as arbitrators have a deserved reputation for delivering fair, balanced, timely, and thoughtful decisions. If you find that, you're halfway home.
Sven, thoughts?
I can only concur. The arbitrator selection, as we said before, it's a crucial stage in any arbitration. The only additional comment I would want to make is going back also to why sometimes it fails, and you can end up in a situation where the forum will actually make the choice of the chairman. I've had a panel once where the parties nominated their arbitrators, and very much in a sort of confrontational mode, so it was quite clear from the outset, even though there is of course the formal requirement of impartiality and independence, it was clear that the party appointed arbitrators would have very pronounced views in terms of the legal issues to be resolved in the arbitration, pronounced views for each party coming from one particular direction and not going both ways. And then the forum chose as chairman somebody who was manifestly not a leader, who had considerable difficulty keeping his panel together and arbitrating rather in the end between the two extremes on his panels, rather than focusing on resolution of the issues that required determination.
Doug?
I think I've said before, I think this is a very inexact science. I mean, I know in the States you have massive efforts and psychologists and all kinds of people involved in jury selection. I mean, notionally you'd do the same kind of thing if you could with arbitrators. But I think the basic problem is there isn't the same kind of information out there. You know, Barry said, you know, the work you do when you find you've got a particular judge, certainly in the States, a huge amount of work goes into investigating this. The basic problem that you have in arbitration is one of the things that we talked about is people like this process to be private and confidential. And as a result, an awful lot of the decisions that are rendered by arbitrators, and particularly good ones, are indeed private and confidential, and you can't get a hold of them. You may, in some cases, be able to get extracts of a decision, but it's not as simple as you might like to think. My own perspective, I'm not a big fan of looking for expert arbitrators. I'm much more a fan of finding an arbitrator who is an intelligent, fair-minded individual who has control of the process and is not afraid to make difficult decisions. That's the kind of person ultimately you want, whether it's an arbitrator or a judge. And finding them is often a challenge. But I think Sven's point is important. that is one of the benefits of the process. You get to do the best you can to select the decision makers. Do not abdicate that process. Work as best you can so that you and the other party decide on who is going to make your decisions. Don't let an organization do it for you. And don't let the court do it for you.
All right. I think equally important, what factors are important in the choice of commercial arbitration counsel? Again, Barry.
Really quick. I've listed 5 factors that are important. Firstly, a counsel that recognizes the difference between arbitration and litigation. Secondly, a counsel that is familiar enough with arbitration to either facilitate or frustrate the client, the objectives of the particular process, depending upon what your client's interests are. There's an old adage that a third point is a good lawyer knows the law, a great lawyer knows the judge. And one of the aspirations that can come out of an arbitration process is selecting counsel that knows the arbitrator, directly or indirectly, is their peered or has had some prior relationship with that person to get a better sense of how to prepare the case most susceptible to that person predisposed to it. My fourth factor, I think, is that as a general rule, if the amount in dispute is low relative to the legal costs, then consider allowing the arbitrator to dispense with oral hearings and or limit pretrial dispositions and discoveries. On the flip side, if you're dealing with a matter either of huge financial importance or a matter of principle, then the opposite will apply. And the fifth and last point is just as retired judges can be inclined to apply skills acquired in the courtroom, lawyers are inclined to employ the strategies that made them successful, and therefore emphasizes the point to choose as arbitration counsel those who are familiar with and comfortable with the arbitration process itself.
Right. I share that last view, and I often express it. I say, you've got to have someone who can think outside the litigation box. Someone who is comfortable not getting full disclosure of documents, someone who is comfortable not doing an examination for discovery, somebody who is comfortable putting the evidence in writing, who can do all that stuff and is not going to start to freak out when they realize that they're not going to get full disclosure of documents or pre-hearing discovery or something like that. Sven, do you have any thoughts on the choice of arbitration counsel?
Principal thought on my side simply would be to emphasize once again what Barry said. It is absolutely crucial when you are at that stage that you want to invoke an arbitral clause or another party has invoked it against you, that you have advice from people who are in the know. People indeed, as you rightly say, who have experience, who have worked together with individual arbitrators and can actually advise you as to who is suitable for your particular dispute and who is not.
Doug?
I think key to this is the involvement and engagement of in-house counsel and the business people whose problem this is, to get them involved in the selection of counsel. Counsel come across differently to business people than they do to in-house counsel. There are different perspectives.
Doug, can you speak up a bit?
Yeah, I think counsel come across differently to business people than they do to fellow lawyers like in-house counsel. The business people often are looking for someone who, when they explain the problem to them, gets it and seems to be able to understand the problem, to be able to relate back what they just heard. As somebody who's going to be able to explain this to the tribunal there before, I think ultimately you want to get the best lawyer you can for the problem that you've got. That may be a litigation lawyer. If you've got a bet the farm piece of dispute that's going to be worth hundreds of millions of dollars, the process that you want before an arbitrator may well be something that looks very much like civil litigation because of the magnitude of the problem. You're going to have to go back to your board of directors and explain, what it is that you're doing with this dispute that is of major significance to the company, particularly if you're a public company. This is a huge issue. So you want the counsel that's appropriate for the dispute that you've got and can convey things to the panel, whether it's in a procedural sense or in the factual and legal sense.
Okay, last topic. We've drafted our arbitration agreement. We've wisely chosen our arbitrator. We've appointed the appropriate counsel. Now, what are the considerations in the actual conduct of the arbitration that can help us realize the benefits that we've talked about? Sven?
Okay. One point I would identify here, and I think I've already spoken a bit to it, is you want to make sure that you have a chairman who is really in charge of the proceedings, who has certain leadership qualities and who's not weak and ends up, as I said before, arbitrating maybe between the people on his panel as opposed to actually arbitrating, moving forward in an impartial and independent manner of the arbitral process. Secondly, for the parties, and here again for in-house counsel in particular, you never want to lose sight of what ultimately your commercial goals are that you want to achieve when you invoke the arbitral clause. So it's very important that once you've decided to go to arbitration and you select a counsel, panel's been constituted, so the whole thing sort of tends to run its course. It's very important that nevertheless you stay in charge as well in-house. You review draft submissions so that you're comfortable that at any one point in time in the process you can intervene and make sure that whatever your commercial goal was or your objective was when you invoked the clause that made you actually go down this process, you can intervene and make sure that you don't lose sight of that. And equally for the panel, I think that's also something to be borne in mind, especially in commercial arbitration. A good panel will always have in view what are the parties' respective commercial interests here, and how can I actually come to a rapid, speedy resolution that will actually respect those interests. And finally, again, it harks back a bit to what we said earlier about the importance of in-house counsel taking a very proactive and engaged role in this process. In-house counsel need to be on board so that you can actually at any one point in time intervene, make use of the rules, and stay on top of the process so that you carry the process as opposed to the process actually ending up at one point in time carrying you. That typically is also one of the situations where you can end up with results, and in arbitration the results are final and binding. You need to live with it.
Doug, any thoughts about the conduct of the arbitration?
I echo some of Sven's thoughts. I mean, I think the engagement of in-house counsel is particularly important. I think it's important for a business to have in-house counsel involved in the arbitration process who are familiar with the process. That's not always the case with some businesses who may have very small in-house legal departments or may have a lawyer in-house who does all kinds of things. They farm work out to outside counsel. If they're not familiar with the process, they're going to be hard-pressed to provide the guidance that outside counsel needs. And so the involvement of the business, I think, is crucial. So if in-house counsel isn't familiar with the process, all the more important that they have the business people whose dispute it is involved in the process, because a lot of the procedural decisions will impact on the business. They impact on the cost, they impact on how this is going to proceed, and the business people themselves will have some things to say about how they would like things to proceed. And they also will have something to say about how they want the company portrayed in the proceedings. The last thing you want is a counsel representing the company doing things, employing tactics that are inconsistent with the corporate values.
Barry, last word to you.
How much time do I have, Doug? 1 minute, okay, because on the way down on the train yesterday, I wrote a minor thesis on this stuff. It may turn into something I'd publish. I call it my 12 commandments, so I'll try to do those in 5 seconds each. Firstly, decide what your objectives are. Key part to successful conducting of an arbitration. Secondly, play within the rules that you've set with the arbitrator that you've chosen. Thirdly, use a single arbitrator generally unless you are in the most complex of cases, and understand that if you are going to go to 3 arbitrators, what the impact that's going to have on scheduling and costs. Plan your case early, commandment number 4. Know your strengths and weaknesses. That will influence how you play. I think the worst thing you can do is just file a case and let it evolve as it plays out. As a first mover, you get an opportunity to shape the impressions and the conversation. Stay on top of the case, commandment number 5. Don't delegate. I'll give you a personal example. I had an arbitration once in a different jurisdiction, and I let one of my regional general counsels take it over with a very experienced outside counsel. I just showed up for the summation arguments. I walked out of the summation arguments. I knew they had the wrong theory, and we lost. But I could do nothing about it, and I blame myself because I had not stayed involved in the process. I hadn't stayed engaged enough. So if you are managing the process, those of us who are on the general counsel side of the perspective, stay involved with your arbitration counsel. Otherwise, you can lose track of it. Commandment number 6, strike a balance on discovery that gives you enough access to allow you to develop your case, but not so much as to make it time-consuming and as expensive as litigation. My general rule about this is that if the stakes are limited, use limited discovery, either limited in the arbitration clause, provide an agreed discovery plan, or choose your arbitrator well. Commandment number 7, identify and disclose your witnesses early. You reduce thereby the risk that you end up with conflicting your arbitrator out based upon witnesses that show up, and that can really mess the process up. Don't treat the arbitration process, item number 8, like a court hearing. Keep motions restricted to key issues and keep memos of law brief and to the point. Commandment number 9, keep evidentiary objections focused on the most relevant and significant matters. Item 10, disrupting the flow of opposing counsel can throw him or her off the game, but in my experience, it will often backfire in an arbitration context. Item number 11, know and read your arbitrator and fashion your arguments accordingly. And finally, be as courteous and respectful as possible. As item number 12. Now, the 2 key objectives of an arbitration are firstly to obtain an arbitration award in your favor, never lose sight of that, and secondly, make sure that that arbitration award is enforceable. That's it.
Just one brief comment. I fully agree with that, what you had to say also about the conduct towards the panel. I don't think it's advisable to engage in scorched earth policy towards the panel. That typically is a good recipe to make sure that the ultimate outcome of the process is an award which will go against you. So courtesy towards the panel, weighing whatever motions you want to bring in terms of the impact it's going to have on the panel is extremely important. Or on the arbitrator, if it's a single arbitrator, it's very important. Scorched earth policy typically doesn't get you where you think you're going to get.
Okay, we're out of time. Thank you, Sven, Barry, Doug. We got to make room for other people to do something else here in this room, but I'm sure all of us would be happy to carry this conversation on out in the hallway and in the bar this evening and throughout the next 2 days. Thank you very much for coming.